People of the State of Michigan versus Frank Edward Racette. This is file 2123738. Mr. Racette is here on video with his attorney, Mr. Gibson, and Mr. Gabriel is the prosecutor. Set for status conference today, but the matter is resolved. Mr. Racette, if you'd raise your right hand. You solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
All right, Mr. Gabriel, what's the offer?
Your Honor, we've indicated that the defendant enters a plea of guilty to the charge of operating while intoxicated, third offense. We would put a cap at the, what I believe is still in place, mandatory requirement of 30 days in jail. With the understanding that between now and sentencing, he will initiate on his own treatment. I believe that the defendant has been through this kind of before. I'm hoping that he'll re-involve himself in some AA, potentially arrange for a substance abuse evaluation, and if recommendations come back before sentencing, start. If he does those things, then all we're going to expect of the court is the 30 days, unless that's altered by sobriety court and how they operate down there.
All right, thank you. Is that correct, Mr. Gibson?
Yes, Your Honor.
All right, Mr. Racette, the offer is that you plead as charged to the charge of operating while intoxicated, third offense, which is a felony and it's punishable by up to 5 years in prison. If not placed in prison, then probation, with a minimum of 30 days to 1 year in jail, at least 48 hours to be served consecutively, 60 to 180 days of community service, rehabilitative programs, cost of prosecution, reimburse the government for any emergency response and expenses for prosecuting the defendant, mandatory vehicle immobilization of not less than 1 year or more than 3 years, and a fine of no less than $500 and no more than $5,000. And that is, the prosecutor saying we'll recommend the bare minimum that's required under the statute if you begin treatment and counseling and the rest again. And we already talked about if you're going to seek sobriety court, it is going to require you to seek that admission before you come back for sentencing, and it's going to require you to get a substance use assessment and to get that process started. So you understand all that?
Yes, sir.
Are you currently on probation or parole anywhere?
No, sir.
All right. So how do you plead to the charge of operating while intoxicated, third offense?
Yes, sir.
How do you plead? Guilty, not guilty?
I'm sorry. My fault.
Okay.
Guilty.
That's okay.
I apologize.
Has anyone promised you anything to make you do this?
No,
Other
sir.
than what we talked about in court today. Anybody
Nope.
promise you anything else?
No, sir, they have not.
Anybody threaten you to make you do this?
Pardon me?
Has anybody threatened you to make you do this?
Oh, no. No, sir.
So you're doing this of your own free will?
Yes, sir, I am.
Now, you understand that if I accept your plea, you'll not have a trial of any kind, and that you'd be giving up the rights you would have had at trial. Those include the right to be tried by a jury, to be presumed innocent, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have the witnesses that testify against you appear in court, and to be able to cross-examine those witnesses, to have the court-ordering witnesses you want to have to appear in court. You'd have the right to remain silent and to not have that silence used against you, or to testify at trial if you wanted to testify. You understand you're giving up all those rights?
Yes, sir, I do.
You also understand that you're giving up, or you may be giving up potential defenses by pleading guilty that you could have at trial.
Yes.
Also, any review of the case or appeal of the case would be by leave and not by right. You understand that?
Yes, sir, I do.
Now, it alleges on December 23rd, 2020, you were in Florence Township, the county of St. Joseph in the state of Michigan. Is that true?
Yes, sir, I was.
And that you were operating a motor vehicle at that time. Is that also true?
Yes, sir.
And that you had been drinking before you were, or while you were driving that motor vehicle?
Yes, sir, I was.
What were you drinking?
Beer. That was it.
Did they do a test of you?
I have no idea.
Oh, you don't remember?
I believe they did at the hospital. I don't know. I was in a lot of pain, so.
Did you get in an accident?
Yes, sir.
Oh, you got in an accident.
I hit a tree.
Okay. And so what did the lab results show that either counsel, Mr. Gabriel or Mr. Gibson?
0.178 grams of alcohol per 100 milliliters of blood.
All right. All right. Mr. Racette, do you also admit you have at least 2 previous convictions for drinking and driving?
Yes, sir, I do.
One from 2002 and one from 1991.
Yes, sir.
Okay. Are counsel satisfied that a factual basis has been established by the defendant's statement of facts?
I am, Your Honor.
Yes.
Are either counsel aware of any other promises, threats, or inducements?
No.
No, Your Honor.
Does the court comply with the court rule?
Court has.
Yes.
I find the plea made is accurate, understanding, voluntary. There's a factual basis, therefore I accept the plea. We'll set this for sentencing on July 30th. And again, Mr. Racette, we're going to send you that packet. We're going to send you the order for the DNA test. You need the packet completed and returned to the Department of Corrections, and then you need to go to the jail to get your blood or your DNA test done, not blood, DNA. And then make sure you show up for the interview. And then if you are interested in sobriety court, you have to follow through. I don't arrange that. That's set up through the district court probation. It's run by Judge Middleton, so Mr. Gibson can assist you if you're seeking entry into sobriety court to get that done. All right,
Yes, sir.
so we'll see you back here on July 30th then, okay?
Yes, sir. Thank you for your time.